One of the most consequential pieces of legislation is now before the Parliament. It's called the Criminal Netas Bills. And at its heart lies a bold principle that no chief minister, no minister, not even the prime minister should continue in office if they are facing grave criminal charges and have been in detention for over 30 days. The bill, as expected, has already sparked heated political and constitutional debate. To help us unpack its legal, constitutional, and democratic implications, we are being joined by one of India's most eminent jurists, Harish Salve, a senior advocate of the Supreme Court, former Solicitor General of India, and one of the sharpest legal minds of our times. Remember, he has argued some of the country's most defining cases. Mr. Salve, really appreciate your time. Let me go straight to my first question, sir. Does this bill truly strengthen accountability and probity in public life as the government is trying to communicate, or does it open the door to new challenges in governance and law?
Well, this bill was long overdue. We have seen a very sorry spectacle over and over again of governments being run from jail. The first was during my experience as Solicitor General, when the then Bihar Chief Minister had gone to jail, at least in lip service to democracy, he had resigned. His wife had become the Chief Minister. And I was, when his bail applications used to come up, I was instructed by the CBI to appear. I have seen photographs of this Bihar jail brought by the CBI people with this former chief minister sitting in the jailer's chair with his feet on the table, and the jailer serving tea and samosas to all the ministers who had come to have a de facto cabinet meeting with him. This was 25 years ago, Marya, and I felt something needs to be done. It has taken 25 years for a chief minister now who was brazen enough to say, well, why should I put somebody else in my place, even if I'm the de facto head of the party? I'm going to be in office. And sometimes I flick through the debates on TV, and it's very interesting to see party people saying he has been given a clean chit if he has been given bail. So today, and we'll come to the bail bit immediately. Today, there has to be some rule by which, by a constitutional law, people who are in office and who are in jail, if they do not have the morality to resign from office, they vacate office. It's a sad day that we have come to a situation where you need a law to say that you must leave office. When the Constitution was framed, the founding fathers did not ever dream that people would be in a situation where they are refused bail by the highest court of the country, which has to be if there's a prima facie case, and despite which they are not demitting office.
Yes, Mr. Salve, you spoke about that case of Lalu Yadav playing out in the context of Bihar, but he had resigned. In the case of Mr. Kejriwal, he continued to govern Delhi from the jail. In our 7-decade-long history, Mr. Salve, no chief minister or minister has served in office after arrest. Mr. Kejriwal certainly was an exception last year. Why should a law then be enacted for an exception? Because normally laws are enacted and exceptions are given.
So maybe there's another way of looking at this, Marya. In 25 years, we have gone first. You see, democracy is something which is always work in progress, and society has to be astute. Society has to be unforgiving when it comes to democracy. Only then will it be preserved. 25 years ago, we found nothing wrong with somebody being openly proclaimed as a de facto chief minister and running from jail. That was 25 years ago. Now, the next 25 years later, we had somebody who said, so what if I'm in jail? I will run from there. So that's the trajectory of our democracy. I think this bill is long overdue. If this is the level of political morality, and if people, if political people in public office feel that it is for them, in their own subjective opinion, to decide whether they are guilty or not, and if they feel they are innocent, then
Okay. Sir, under the
there's nothing
principles
wrong.
of natural justice, an individual is considered innocent until proven guilty. Yet the new bill proposes the removal of a sitting minister, chief minister, or even the prime minister during the course of investigation and trial, rather than after conviction. Isn't this a breach of that very principle?
Natural justice is a principle of everybody being heard before a decision is taken. It has nothing to do with guilt or innocence. Criminal jurisprudence is based on a presumption of innocence, which means that when a prosecution is brought, the prosecution has to prove the guilt. And I think a very regressive provision has been made in the money laundering law, which reverses the burden of proof. Hopefully, Supreme Court will have a second look at it and maybe strike it down. But be that as it may, that's a principle of jurisprudence which says that the prosecution has to establish the guilt. That's what you mean by saying innocent until proven guilty. Arrest takes place by an investigating agency, but the matter then gets carried to a court. And the court, ultimately, today we have seen High Court and even the Supreme Court does on occasion entertain cases involving grant or release, refusal of bail. And the Supreme Court will take into account the need for a prima facie case where it's a political neta. So I don't think the principle of, and it has to be on a prima facie base. Now today, what you're saying is somebody who the courts feel prima facie cannot be granted bail
Okay.
will continue to govern. That is, if you are willing to have that kind of a democracy, well, so be it. I
Okay.
don't think that's what was ever intended.
Let me tell you what opposition leaders are saying here, Mr. Salve. They are arguing that this bill could pave the way for political misuse.
Again,
Let's look at this report. In last
so
11 years, there have been at least 13 instances, sir, where sitting ministers have been detained, and most of them by the Enforcement Directorate and the CBI. And most of these sitting ministers ended up spending more than 30 days in jail. In this context, isn't the opposition justified in its concern?
no. What we as personally speaking, what as a lawyer I'm concerned is where the Supreme Court has ended up with a law of bail. That needs to be fixed. But that is unrelated to netas. That is even for a common man who's arrested. Justice Krishna Iyer had coined the expression, bail not jail should be the rule, bail should be the exception, except where it is a very serious case of murder or violent crime, where the law itself forever contemplates that the rule is custody. It's only the bail which will be an exception if you find no case. So this is how the law has been forever. And the courts will take into account that somebody who is holding high office in 30 days will vacate office. So the courts, and it's a bail applications are finished within 30 days. There's no big deal. And you want to make it 45 days, then it's gone to a joint committee, parliamentary committee, they can make it 45 days or make it 60 days. Or they can make an exception till the first bail application is pending or some such thing. Those are matters of minutiae. Those details can always be worked out. But in principle, what's wrong with this? That if prima facie you're guilty of commission of a serious crime, if you have not had the moral courage to resign, the law will remove you from office.
Mr. Salve, arrest in India, unlike many Western jurisdictions, is purely an executive function. There is no outside assessment of evidence gathered. Is it fair then to hand over a loaded gun in many ways to the law enforcers of the state?
There is. The initial arrest is by the agencies, everywhere in the world, but there is judicial oversight. Even in India, the arrest is two ways. One is the court issues a warrant, the other is cases where the investigating agency, i.e., the police, has the right to arrest. So that is available. Whether the arrests being made left, right, and center by the enforcement directorate are right or wrong has nothing to do with netas. What about a businessman who's arrested? What about a guy, a person doing a job who's arrested? Everybody's trial is as sacred to our constitution. Everybody's freedom is as sacred to our constitution. So that's a separate debate. But today, the notion that this is purely executive is wrong, because it says if for 30 days you continue in custody, you can never continue in custody for 30 days without court intervention. Now you feel 30 is too short a day, well, the Joint Parliamentary Committee can make it 45 days. It's the principle. And in the principle, if a court finds prima facie there is a case against you, why should you not demit office? And if you don't demit office, why should you protest? And please notice somewhere along the way, from a duty and a trust, a office is now becoming a privilege and an entitlement. And it's this mindset which needs to be addressed.
So look at the conviction rates in cases of political nature, and yet a person must quit his elected post without any court of law adjudicating guilt as per this constitution amendment?
Marya, if a senior manager in your office is arrested and stays inside for 30 days, would he continue in his office or would you suspend him? A civil servant who's arrested and put in jail, what happens to him? He's suspended. So, has this electoral office become such a high value entitlement that despite being in jail, in custody, nobody can snatch this away from you? What mindset are we bringing to bear? Or is it that if somebody has been found by the highest court of the country to be prima facie involved in an offense, he must still continue to hold high office?
Mr. Salve, the 244th Law Commission report, which was, in fact, rejected proposals that disqualification of a legislator should take place at the stage of filing a charge sheet or when a court takes cognizance of an offense. It observed that disqualifying someone before the application of judicial mind would violate the principles of natural justice and effectively punish a person even before proceedings begin. Should the threshold then be set at the stage of filing of charge sheet?
I'm sorry, you are not disqualified from office if you are in custody. You are only told that during the period you are in custody, you will not hold high office. This has always been the constitutional morality. Now we are making it the constitutional legality. Disqualification, what you're speaking about, is that you get elected, you lose. The moment a charge sheet is filed, you may be not in custody. The threshold for a charge sheet is very low, very low. At that stage where a charge sheet is filed, the only challenge which you can bring is if you read the charges as they are. The charges are not made out. Framing of charges is the next stage, where there is a prima facie case. There again, it is prima facie. Now, balancing a prima facie case as against a disqualification, which is permanent, is very different from saying during the period in which you are in custody, step aside. We will not have high offices being run from our jails. What is the messagery you're creating in a democracy?
Okay, so you know it better than the most, Mr. Salve, as a distinguished lawyer, that an arrest by itself proves nothing. How can that then become the crucible of guilt?
Arrest is not the crucible. An arrest followed up by a refusal to obtain bail, where a court takes into account the consequences of not granting you bail, is that you will vacate your office. So, it doesn't say the moment you are arrested, you will lose your office. 30 days in custody. And I said 30 is not a sacrosanct figure, I'm sure. When you are in prolonged custody, post arrest for a serious offense, should you be allowed to hold high office and discharge that sacred trust to the people? If you ask that question, you come to a different answer. If you say it's a hard won entitlement for which a lot of money and effort has been invested, and it's like a property right, don't take it away from me on mere arrest, you come to a different conclusion. So it's a question of what do you think of public, of being in high public office? Is it a sacred duty or is it an entitlement which you have won?
But Mr. Salve, the question really is, and I'm going to quote a part of this clause, that when detention is linked any law for the time being in force, do you feel that the quantum of perhaps the requisite crime for the bill is too wide?
5 years or more. 5 years or more is by definition serious offense. This is an established yardstick.
And what would you tell those who are saying that this bill distorts parliamentary democracy, which is part of the basic structure? And of course, as you said, that the JPC will perhaps... Yes, go ahead, sir.
What distorts parliamentary democracy more? Having ministers sitting in jail and who courts refuse to give bail to? I don't know whether that distorts democracy or whether asking somebody who's a minister saying, please do not discharge the duty under the Constitution during such period as you are in custody of the state, whether that violates. I think we've got our ideas completely mixed up. We are looking like this is some privilege or entitlement. Once you become a minister, it's a privilege or entitlement. And how dare you ask me to go just because I'm in jail? And is that our new definition of democracy? Then I don't recognize this democracy. Maybe I'm too old.
Mr. Salve, the law envisages several aspects of it. When you have gone through the bill, you have read the copy of this bill, what do you think really makes this bill, and can it really stand the test of judicial scrutiny?
Well, I have some little experience of constitutional law. I do not see on what principle of law this should be struck down. How does it violate I don't know whether a minister in jail violates the basic structure or the basic morality of the Constitution, or whether a law which says if you do not get bail, sorry, you will not hold high office, you continue to be an MP, you continue to be an MLA, you will continue wherever you are. But for that period during which you are in custody, you will not hold high office. I don't know which of the two is more compatible with democracy.
But sir, look at the sheer number of arrests on the other side of the fence while Treasury benches remains untouched. The fear of misuse of agencies then seems to be genuine.
Now, what are the courts doing? Who is in today, one of the primary functions of a court is to be a check and safeguard against abuse of power. One wrong person is jail. One wrong person in jail is one blot on the Supreme Court of India and the High Courts of India. The most sacred, in any democracy, the most sacred thing is the liberty of not a neta, is the liberty of a citizen. And that this debate, suddenly the neta's conscience is open to the draconian nature of the laws which they have all made. Only when they start losing office, I'm sorry, it is these people who have made these laws. And you have made these laws. If the laws are draconian, well, who voted for them? And our judges have upheld these laws. According to me, the PMLA judgment is horribly wrong, but it is a judgment of the Supreme Court. So, if what is sauce for the goose is sauce for the gander, it is good for the average citizenry of it. Hey, your heart doesn't bleed. Your heart bleeds when a neta is affected. We have suddenly drifted from a public duty to an entitlement. And that's a more fundamental breakdown of the basic structure of the Constitution.
Let me give you some examples here, Mr. Salve. Sitting ministers, chief ministers who have been arrested. Chief ministers like Jayalalitha, Shibu Soren, A. Raja, Jagannath Mishra were eventually acquitted by the top court. How fair is it then to remove a sitting minister even before, even before the final order?
Let's go one by one. Jayalalitha, I think, was ultimately convicted, if I remember correctly. In any case, Shakil was convicted for connected offences. I think Jayalalitha died in office or something. Shibu Soren was, I think, convicted. The other minister, Raja, was not arrested. Raja's case is a new genre of cases which we are now seeing, where the Supreme Court takes it upon itself to constitute an SIT, BIT, CIT, or God knows what, and pursue as a magistrate criminal charges just because of some notion of breakdown of democracy because of some arbitrariness and crony capitalism. Ultimately, what happened? I have appeared in two of these cases, Marya. We only talk about Raja. Do you know what the Ruya family lived through for the bogus case against them, all arising out of this 2G? Do you know what Mr. Sunil Mittal lived through for the bogus cases on him? Nobody talks about them. We only talk about Raja and the lady. So this is what is happening. This is double standards. That whole 2G was such a big mistake by the Supreme Court. There are two occasions on which Supreme Court has done this, and on both occasions it's ended up with a big blank. Let's go back to the Jain Hawala diaries, where the Supreme Court started this business about having a special investigation team, etc., etc. What has happened to that? And do you remember in the Jain Hawala time, whichever minister name came and he was arrested, he resigned. What has happened to that morality? And everybody said this charge is bogus. But till I am cleared, Advani ji, I remember, Advani ji said, this charge has been brought against me. I will not take public office till this charge is cleared. What has happened to that? Were those people acting against the constitution when they did that? So, and 2G was another misadventure of the Supreme Court. There have been two misadventures, Jain Hawala Diary and 2G. And I have noticed, and I make bold to say so on your channel, once the Supreme Court asks the agency to investigate, and you have people, activists acting as lawyers in court, screaming at the agencies feel the safer course is arrest and put inside. And if on a Supreme Court, and then you show the Supreme Court, I have done this. Now, when that goes to a magistrate, what is he going to do? He'll say, oh my God, Supreme Court is investigating, overseeing. Supreme Court has seen that he's been put in jail. How can I grant him? And then you have Supreme Court making all sorts of rules, saying you will not have the benefit of going to the High Court. You must come only to us in the coal scandal. This coal scandal is going to be another third major mega situation. So those are aberrations on our democracy. I call them aberrations on our democracy.
Okay, my last question to you. Mr. Salve, my last question, sir. The United Kingdom has a ministerial code which essentially expects ministers to resign after breaching public trust. Correct. Do you think it's better to have a code of that nature, which will be more of a gentleman's understanding rather than law?
Didn't we have this all these years? Go back to 1991, 92, when the Jain Hawala Diaries, I think it was 92, 93, when the Jain Hawala Diaries story started. Please go back to there. 95, 96. And what did each public functionary say? Didn't he say that, all right, I agree, I will not continue in office? So there was a code. It is now for the first time we see people say, oh, we have been elected to office and it is for our subjective judgment. We say this is a false case, we will not resign. Where does the law say I have to resign? Where does the constitution say I have to resign? So the codes don't work now anymore. Because I go back to my starting point, Marya. This mindset has to change. This is a sacred duty. Today you treat this as an entitlement. Then you say, show me the law under which my property is seized. So it's like saying, show me the law under which my office is forfeit.
Mr. Salve, always a pleasure speaking to you, sir. Thank you for speaking to India today, and thank you for sharing your thoughts on these bills. Of course, there's a lot of political division that we are seeing on it, but thanks for putting this in context for our viewers as a top jurist of India.
Thank you.